So what if the American criminal justice system isn't just a little flawed, but is fundamentally broken? That's the core argument from a really powerful article by Clark Neely of the CATO Institute. Today, we're going to walk through his stark critique, which paints a picture of a system he says is, well, rotten to its core.
Right off the bat, the author doesn't pull any punches. He starts with this incredibly blunt statement. This isn't about tweaking a few policies. He's challenging the entire foundation, arguing that the whole thing is broken from the ground up.
And he doesn't stop there. He uses this image, a raging dumpster fire of injustice, to give you a sense of total chaos and systemic failure. I mean, that language is designed to be provocative, to really make you feel the urgency of the problems he's about to lay out.
Okay, so how do you back up a claim that big? Well, the author structures his entire case around what he calls 3 fundamental pathologies. Think of these as the 3 core sicknesses that he believes are poisoning the entire system. Let's break them down.
So the first problem he points to is something called over-criminalization. The idea is pretty simple. The system is supposed to protect us from real threats, violence, theft, that kind of thing. But he argues it's grown way beyond that, and now it's being used to punish peaceful people for behavior that isn't really hurting anyone.
To put it another way, his point is that we've made so many things illegal that don't have anything to do with right and wrong and pose no real danger to society. And when the government uses its power to enforce those laws, he argues it's basically an abuse of that power. And to show you just how far this can go, he brings up a real-world example that just sounds, well, almost absurd. A local law that actually made it illegal to wear saggy pants. This obviously has nothing to do with public safety, right? It's about policing style, and he uses it to show just how deep the law can reach into our personal lives. And get this wasn't just some symbolic law that sat on the books. It was enforced. It led to over 700 arrests. But here's the detail the author really zeroes in on. A staggering 96% of those arrested were black men, which highlights the incredibly disproportionate impact these kinds of laws can have.
The author then points to what he sees as total arbitrariness. He contrasts marijuana with alcohol and nicotine. Now, objectively, marijuana is safer. Yet while governments were making a profit from legal alcohol sales, arrests for marijuana were actually rising in some places. He calls this a profound and morally indefensible contradiction.
Okay, that brings us to the second pathology he identifies, something he calls point and convict adjudication. It's a fancy term, but what it's really about is the collapse of the trial process we all imagine, and specifically the near total disappearance of the trial by jury.
I mean, just look at this slide. The Constitution guarantees you a trial by jury, but let this number really sink in. The data he's using shows that over 95% of all criminal convictions in this country now come from a guilty plea. His conclusion? America doesn't have a system of trials anymore. It has a system of pleas.
So you have to ask, how do you get 95% of people to just give up their constitutional right to a trial? The author's answer is something he calls coercive plea bargaining. He argues that prosecutors use an unbelievable amount of pressure to force these guilty pleas, whether the person is actually guilty or not.
He's got another really powerful metaphor for this process, the criminal justice wood chipper. His argument is that by getting rid of the slow, careful process of a jury trial, the government has created this impersonal machine that's just designed to process people into convicts as fast as possible.
And these are the specific tools or levers that he claims prosecutors use to crank up that pressure. It can start with pretrial detention, just holding you in jail before you're ever convicted. Then they can stack up a ton of different charges to make the potential sentence look terrifying. They use harsh mandatory minimums. And finally, there's the threat of a much worse sentence, the trial penalty, if you dare go to court and lose. When you put all that together, pleading guilty can feel like the only sane option, even if you're innocent.
And he doesn't just blame prosecutors. He says the courts have pretty much just let all this happen. By basically refusing to see these tactics as unconstitutional, he claims the judiciary has become complicit in taking apart our trial system.
This leads us right into the third and final pathology, a culture of what he calls near-zero accountability. This is all about what happens, or more to the point, what doesn't happen, when the people with all the power, the police and prosecutors, are the ones who break the law.
His claim here is absolutely stark. He says that the very people who hold the power of the state, sometimes literally the power of life and death, operate with almost no meaningful consequences when they do something wrong.
He frames this as a massive double standard.
On one side, you have prosecutors in court demanding responsibility and accountability from regular people. But on the other side, when an official is accused of misconduct, he argues the system just closes ranks and protects its own, offering excuses and leniency.
He points to a few specific barriers that make accountability so hard. There are legal shields, like qualified immunity, which makes it incredibly difficult to sue government officials. He notes that it's super rare for officers to be criminally prosecuted, unless there's a viral video. And even when you can sue in civil court, he argues the cases are often made toothless.
Okay, so after laying out these three deep systemic problems, the author brings it all home to answer a really critical question. Who is actually paying the price for this broken system he's describing?
And his conclusion is that the immense weight of all this dysfunction falls hardest on those with the least power in society, specifically marginalized communities and people of color. He says the reasons why are complex for sure, but the reality of these racial disparities is just undeniable.
And this really gets to the moral heart of his entire argument. He concludes that the end result of all these disparities is a system that sends a clear and painful message, that some lives are simply valued less than others. It's a perception, he says, that is both correct and a legitimate reason for anger.
So ultimately, this entire critique leads to a pretty profound conclusion, that the system has lost its moral authority, its legitimacy. And that leaves all of us with a final, really challenging question to think about. If his diagnosis is right, what would it actually take to fix a system this broken and restore that legitimacy?